Good morning, everyone. Welcome to WorkCover Queensland's Common Law webinar on manual handling injuries in the workplace. My name is Tim Loos. I'm a senior lawyer with WorkCover Queensland, and I'm your host today. Before we begin, we would like to acknowledge and pay our respects to the Yagara and Turrbal peoples as the traditional custodians of the land in which we work and from which we are speaking today. We thank the traditional custodians and their elders, past and present, for their ongoing connection to land, waters, culture, and community. Some housekeeping. We record these sessions and we later send out a link via email of the recorded session, and we also send out the slide pack with the links to material that you'll see throughout the presentation. We also send out a short survey, so if you want to provide some feedback, please do. We welcome it. The recorded video is also uploaded to WorkCover Queensland's YouTube channel and via socials. You can also find all of our past common law webinars on our public YouTube channel, going back a few years there. You can submit questions during the course of this webinar. There's a Q&A button at the toolbar at the top of your screen, or use the chat function. We do our best to answer the questions that come in at the end, time permitting. We'll also be addressing some questions that were submitted at the time of registration. Those will just be rolled into the end of the presentation. We can't answer any claim or policy specific queries, so if you do have anything that's quite specific, please reach out to your relationship manager if you've got one, or a customer advisor or lawyer handling a current claim for you. If there's any technical issues, please refer to the help information under the More button, which is in the toolbar at the top. And finally, for housekeeping, just a reminder that anything that's said in the presentation today by WorkCover or by our guest speakers is general information only and shouldn't be taken as legal advice. If I could now introduce our guest speakers from Hughes and Loos. Duncan Hutchings has 20 years of personal injury law experience working for both plaintiffs and defendants in the fields of workers' compensation, public liability, CTP, and medical negligence. For the past 15 years, he has represented WorkCover Queensland in defence of common law damages claims in many industries, including transport, health, mining, retail, and manufacturing. Welcome, Duncan. Also here, Elizabeth Bainbridge-Brown. Elizabeth has over 11 years post-admission experience in personal injury claims and managing claims across the workers' compensation, CTP, and public liability schemes. Since 2011, she has worked exclusively in the field of defendant personal injury claims, during which time she's been involved in the preparation and defence of matters from statutory review to QIRC appeal through pre-proceedings and into litigation. Welcome, Elizabeth. And that's all from me for now. I'll hand over to our guest speakers. Thank you.
Thanks, Tim. Good morning, everyone, and welcome to this webinar on manual handling injuries in the workplace. This is not the cheeriest topic at this festive time of year, but it's a very important topic for employers because so many claims for damages arise out of manual handling injuries at work. This seminar is directed to employers, and in particular, employers of workers who perform manual tasks. It is focused on common law damages claims arising out of injuries from manual tasks. I should say at the outset that Liz and I are not safety experts. We are lawyers engaged by WorkCover to defend claims for damages by injured workers against their employers. If there's just one thing that we hope employers take away from this presentation today, it will be some practical tips and strategies about how they can best be able to defend these common law claims effectively. A likely consequence of following these tips and strategies is that some or many manual handling injuries could be prevented in the first place. So to start, we'll have a general discussion about manual handling injuries at work and the employer's duty of care. Then Liz and I will give you some examples of how the courts approach these injuries. We'll discuss the main takeaways from these cases and then give employers some practical tips on how to defend damages claims arising out of manual handling injuries. Then we'll open up to questions. So why this topic? Sprains and strains are the most common injury type to Queensland workers by far. They range from the most minor and temporary muscle strains to those injuries requiring multiple surgeries which have a devastating impact on a worker's capacity to work. The most common type of manual handling injury, unsurprisingly, is sprains and strains to the back, but also common are injuries to the shoulders, knees and ankles. The injuries can occur in a separate, discrete incident, or they can occur over a period of time. So what is a hazardous manual task? The term is defined in the Work Health and Safety Regulation and the Manual Tasks Code of Practice. It is anything that involves the lifting of weight or the application of force or exposure to vibration or repetition or awkward posture. The definition is very broad and could conceivably apply to any manual task in the workplace.
Thanks, Duncan, and good morning, everyone. The question then turns to what we as employers need to do to ensure that we are taking appropriate steps to manage risks in the workplace. On the slide, you'll see we provided links to the Work Health and Safety Regulation and the Hazardous Manual Tasks Code of Practice. These are both relevant but not determinative, and you should be aware of these and how they impact on your specific industry. The employer's duty of care is assessed at common law, which means that we have to consider the case law and also the legislation before us. Now, that duty of care is a non-delegable duty of care, which is a very high duty of care and one which employers cannot ordinarily escape. In its simplest form, it is the duty to take reasonable care to avoid a foreseeable risk of injury. It is not necessary for the employer to safeguard against all perils, which you will see from a case we discuss of Solomona later today. The duty of care for employers practically means that employers need to provide their employees with a safe place of work, a safe system of work, but also to establish, maintain and enforce that system. Now, turning to the legislation, I've given you a link there to Section 305 capital B of the Workers' Compensation and Rehabilitation Act, which provides the definition of the employer's duty of care. Now, it largely restates the common law position. We as lawyers are looking to assess whether the risk was foreseeable, i.e. whether a person in the position of the employer knew or ought reasonably have to have known of the risk, whether the risk was not insignificant, and whether a reasonable person would have taken precautions. Now, considering if a reasonable person should have taken precautions, what we need to do is we need to look at the probability of the injury occurring if care were not taken, the likely seriousness of the injury, and the burden of taking those precautions. In practicality, what that means for us and for each case that we are looking at, we are considering and balancing, was the risk a minor or a major risk of injury? Say, are we looking at a scrape or an amputation? We're looking at what could be done to manage that risk, be it through training, through exclusion zones, or through new equipment. We're then looking at whether those alternatives are reasonable, which requires a consideration of how easy was it to provide that training to staff? How easy was it to enforce exclusion zones? Or was it very, very expensive to obtain new equipment? A court will look at the magnitude of the risk and the probability of it occurring, along with the expense, difficulty and inconvenience to the employer in taking that step.
Okay, so turning now to the first of the cases, Duncan and Tabcorp is an interesting one and a rather famous case amongst personal injury lawyers. The injured worker, a secretary, suffered a back injury when picking up a box of printer paper weighing 12 kilograms. At first glance, one might think this is a harmless, innocuous task, and in fact, that is what the employer argued in this case. But the judge looked very carefully at the incident, finding that the plaintiff had to reach down between a wall and a printer to retrieve the box of printer paper. And when lifting it, she had to twist and lift simultaneously. It was the twisting and lifting simultaneously in cramped, awkward conditions that caused the injury. The judge found that the employer could have prevented this incident by training her in manual handling and placing the boxes on her desk as opposed to the floor. The court found that these preventative steps were cheap and simple. The court found the employer breached its duty of care and the plaintiff was successful. I want to point out that this is the case we quote to employers the most in terms of manual handling injuries. It is a glaring example of how a seemingly simple task can, on closer inspection, be hazardous. In Mabrori and Medina, the injured worker was preparing for the breakfast service at the Travelodge in Rockhampton. She was required to check the level of ice in a bucket behind the bar. The bucket, filled with ice, weighed 15 kilograms. She had to lift it to chest height and out in front of her to get it up and over a chain in the bar area. Now, 15 kilograms is not a very heavy weight to lift, but the bucket had no handles, and to get it over the chain, she had to pick it up in a chicken wing type movement. Her shoulder was injured. The court found that this was an awkward lift and an accident waiting to happen. The employer did provide some initial manual handling training to the claimant, but it didn't address the specific risk associated with lifting the bucket. The employer argued that no employee complained about the bucket in 5 years. The court said that was no defence because if a risk assessment had been done, it would have identified this risk. The court found that the employer ought to have had in place a system whereby the bucket wasn't filled completely, or otherwise designed a system whereby the worker didn't have to lift the bucket over a chain and away from the body. Plaintiff succeeded in that case. Mr. Burhane was required in his role as a picker to load pallets with cartons of food weighing up to 17 kilograms. He had to lift about 1,000 cartons per day. His manual handling training was actually quite good. He was directed to keep his elbows low and near the body when lifting. He was told not to overreach, to lift only one carton at a time, and to put small items in the middle of the pallet and large, heavy ones on the corners. However, it was found that in practice, workers picked up more than one carton at a time and often took shortcuts, such as leaning across the pallet rather than walking around it. It also found that workers were left to their own devices as to how to pack a pallet. The court found, therefore, that supervision was lacking. The Woolworths' own instructions and guidelines weren't followed. A key feature of this case is that workers were under time pressure to meet packing targets, which likely encouraged the taking of shortcuts.
The next case we have for you is the case of Solomona. Now, Ms. Solomona was a 33-year-old who was employed as a customer service representative at a BP service station. Among her duties was a requirement that she refill the shelves and change the products. On the day of the incident, she was instructed to complete a stock replenishment, which meant that she had to lift and rearrange the ice cream baskets in a large freezer. Now, she alleged that the bottom of the basket had become frozen, and she continued to pull on the basket to try and remove it, and in doing so, she injured her lower back. Now, the case at trial, there was no evidence at trial about the specific weight of the basket. She alleged she had not done this specific task before, but based on the evidence from a co-worker, the court did not accept this. Ms. Solomona's co-worker gave evidence that it was a matter of common sense to do a visual check to see if there was a build-up of ice, and that this was a fairly routine task. The court was satisfied in this case that the employer had provided an appropriate moderate level of training and instruction for what was a fairly routine task. In terms of what the court considered a moderate level of training, this plaintiff had undertaken an orientation and an induction, which included an 8-hour online training course, which covered lifting and handling items. She had received a learner's handbook, which set out and discussed various manual handling hazards. She had received activity cards, which included a card for the subject task and showed her what she needed to do for that task. Now, another thing that came out at the trial, there was evidence given by the service station manager that there were no specific instructions or directions provided as to how to deal with the baskets in the freezer becoming stuck with ice. There was also no evidence at the trial that the defendant was aware of any prior incidents or complaints, and there were no changes to the system of work post-incident. Now, the plaintiff was unsuccessful at trial, and the court noted particularly the fact that there was no prior complaints or injuries, coupled with the fact that the task was a fairly routine one, which meant that the degree of risk of harm was sufficiently low to be considered insignificant. The court also commented that the avoidance of a sudden or jerky movements, which was the risk that eventuated in this case by trying to tug on the basket, was identified particularly in the defendant's documentation specific to this task. Now, from this case, you can see an employer is entitled to expect an employee will exercise care in carrying out a straightforward or routine task. The training provided by the employer was considered appropriate. It had been provided within 12 months of the incident. The training was specific to the task at hand that she was completing. It went beyond a tick and flick document and specifically considered the type of risk that eventuated being the sudden movement when she attempted to lift the basket. Now, the next case I have is the case of Whitley and Aldi stores. The plaintiff, Mrs. Nicola Whitley, was a 40-year-old woman who was a checkout operator at an Aldi store in Queensland. Now, she allegedly suffered a left wrist injury when she was required to move a 4-kilogram bag of dry dog food from a conveyor belt to a scanner. Now, she alleged at the trial that she had to manually scan the bag rather than simply being able to enter in a code. She also said that she had to use the paddle grip technique, in which she accepted she had been trained, as the product could not be pushed across the small step up, which was about 0.5 millimetres at the end of the conveyor and then back down onto the scales. The case at trial centred on the use of the paddle grip technique, which involved an operator moving one hand behind the product and pushing it to the scanner. Now, the plaintiff alleged that the small step up, which you'll recall was 0.05 millimetres, meant that if she did not lift and drag the product, it could break. Now, in this case, the defendant had a liability expert who gave evidence at the trial about the height of the step up, firstly being that it was 0.05 millimetres, and that the bag was able to negotiate that step up without any perceptible change in force, that the edge was not sharp, and that the edge did not cut the packaging, despite the expert dragging the bag across the metal edge 10 times. In this case, we also had the Aldi store manager giving evidence that she had used the paddle grip technique to scan the product herself and had never experienced any difficulties. The defendant's evidence was accepted, and the plaintiff failed at trial on the basis that it was not unsafe to use the paddle grip for this task. For me, this case demonstrates the importance of providing training which is relevant to the specific task, and in this case, the paddle grip technique which she had been trained in was proper and appropriate. A further important takeaway is that the store manager was able to speak to her own experience about how she would complete the task, that she had completed the task in the past, and that combined with the expert evidence was relied upon and accepted by the judge at trial. The next case we have is the case of Darcy. Now, this is a case at the other end of the spectrum where the plaintiff was in fact successful in her claim. The plaintiff is a 30-year-old Mrs. Natalie Darcy, who was employed as a personal care worker by Spiritus. She was responsible for transporting clients to and from medical appointments. Now, on the date of incident, she attempted to extract a wheelie walker from the boot of the car when it caught on an object. She tried to jiggle it free, and in doing so, she suffered a lower back injury. Now, the weight of the wheelie walker was not proven at trial, but it was described as weighing about 5.6 kilograms. Now, Ms. Darcy alleged that the employer had breached its duty of care as it did not train her how to unload the walker specifically. Now, Spiritus alleged that unloading the device was a simple and everyday task that did not require any specific training or instruction. Now, the employer did provide some manual handling instructions. There was some manual handling guidelines which referred to manual handling of objects. It said that items should be secure, there should be adequate space around the object for the manual handling technique to be used. But importantly, in my view, the document didn't actually talk about what manual handling technique she should use. The guide also referred to managers being responsible for providing training and that the workers would complete a competency assessment at the start of their employment. The plaintiff in this case also received a self-directed learning package regarding workplace health and safety orientation. However, there was only a very minor passing mention of the wheelie walker. Now, the court rejected the employer's submission that this was a simple and everyday task. The court accepted that there was a significant risk of injury in circumstances where this was a task that the plaintiff was regularly required to complete, and that there had been no instruction to her in respect of the proper manual handling techniques that she should use. The court also took into account the burden of the employer taking those precautions and said that that precaution would have been entirely minimal. Now, something that I wanted to add in today, you may have noticed that all the cases we've discussed so far involve relatively light weights. They all come up sub 15 kilograms. Now, there is no direction in the Code of Practice or the Work Safety Regulation or otherwise any direction specifically made as to what constitutes a safe weight for workers to lift. And what is considered safe will depend on a multitude of factors. As a very, very general guideline, I would suggest that anything more than 30 kilograms is going to be problematic. But again, depends very much on the specific nature of the work and the specific task being completed. And a lift involving a lighter weight, but with greater forces or repetition could be equally as risky. I suspect the reason we don't have any cases to speak to which discuss lifting heavy weights is rather clearly the heavier the weight, the higher the risk of injury, and presumably these claims are being settled in the pre-proceedings. For employers who have workers lifting heavy weights, what I would say very briefly is that it is essential that you are very carefully considering the weights being lifted by your staff and whether there is a safer way to complete this task. Now, this might involve a discussion about whether the lift can be completed as a joint lift with multiple workers, but that unfortunately comes with its own additional risks. I would say best practice is going to likely be to look at what mechanical lifting aids are available that can be utilised to minimise or completely remove the need to complete manual handling in your organisation.
Okay, so the last case we'll look at is that of Norsgaard and Aldi stores. This is another case involving a store packer in a supermarket. The plaintiff was required to lift cartons of product from a pallet onto supermarket shelves. It was repetitive work done under time pressure. Manual handling training was provided to the plaintiff, but the court found that it was inadequate. The training involved watching a video on how to lift a box, but the simple lifting of a box bore little resemblance to the types of products she had to handle. It also found that the training was too easy in that the plaintiff was required to complete a questionnaire, but it consisted of only 3 questions for which the answers were obvious. It was not a true test of the inductee's knowledge, the court said. There was some retraining 6 months after she started work, but it contained no direction as to the maximum weight she should lift or the maximum number of items she should lift. In other words, there was no practical element to the training. Another problem for the defendant was that there was a buddy system whereby the plaintiff was partnered up with an experienced worker during her first week of work, but it was an informal arrangement and it wasn't documented. All in all, the court found that the plaintiff and other workers were left to their own devices and there was inadequate supervision. The plaintiff was successful. So we're now going to talk about the main takeaways from these cases. I guess the first takeaway is that it is not just those workers doing heavy labour jobs who get injured. The cases we have discussed include an office worker and a personal carer doing what seemed like simple light tasks, but on closer inspection, they weren't. Even light weights can cause an injury. In the cases we've discussed, the items being lifted didn't weigh more than 20 kilograms, but it was a combination of factors which made the task hazardous, including repetition, the size of the item being lifted, the force on the body, whether the task was awkward or performed in cramped conditions and under time pressures. The cases we discussed, some or all of the manual handling training was good, but there was no reliable evidence that it was enforced through supervision. Just as important as the training is evidence that it is in place and enforced. The cases make it clear generally that manual handling cases are inherently difficult to defend, as they often turn on matters solely in the knowledge of the worker. For example, how they undertook a particular lift, their recollection of the environment around them at the time, their interpretation of instructions on how to undertake a task if instructions were given, and whether the system of work was enforced.
Now, one of the clear themes that comes through in manual handling cases, and hopefully is coming through from the discussion so far today, is that general instruction for manual handling is not sufficient. You'll recall in the Darcy case, which was the lifting the wheelie walker from the boot, some basic instruction was provided, but there were no specific manual handling techniques discussed, and this resulted in the employer being liable. Comparatively, you can see from the Solomona and the Whitley cases, where the employers were successful, the training was specific to the activities that the workers were performing. It was not just a tick and flick, but was actual training performed over a period of time. The training considered the actual risks that were inherently involved in the tasks and provided actual manual handling techniques and instruction. It is, in my view, critical importance for employers to provide training and instruction, even if the task appears simple and straightforward, and even more so if the task is required to be completed regularly. It's also important to consider the need for refresher training and to ensure that your manual handling training is being repeated at regular intervals, perhaps every 6 to 12 months for your workers.
Okay, so we're now going to turn to the most important part of this webinar, which is the practical tips and strategies we can give to employers who are faced with damages claims arising out of manual handling injuries. I think most importantly, as we've discussed already, manual handling training must be tailored to specific tasks and risks and not generic in nature. The bog standard manual handling training that we come across all the time involves showing a worker a diagram or a video on how to lift a box using manual handling principles. Those principles are typically to assess the load, lift with your legs, not your back, keep the load close to the torso, and don't twist and lift. Now, that's all well and good for lifting a box, but it's rare that work tasks are that simple. Secondly, it is imperative that manual handling training and any refresher training is documented. The training for more complex tasks ideally would involve a theoretical and a practical component, and the worker should be quizzed on the training, and they should confirm their knowledge and understanding by signing the training document and or the quiz. That signature can be on paper or it can be digital. Now, you've all heard the mantra when it comes to buying property, namely location, location, location. Well, the mantra when it comes to defending common law claims is evidence, evidence, evidence. The more you can document in terms of training and reminders, the better. Staff meetings and toolbox talks are a good opportunity to remind staff about manual handling risks, and they are really helpful for new and emerging risks identified during the course of a job or a project. Ideally, the workers who attend these meetings would sign their name to confirm they attended and they understood the instructions given. For those employers who do work for which manual handling is an everyday activity, it would be prudent for them to make manual handling risks a recurring item on the toolbox talk or the staff meeting agenda. Now, as a side note, we encourage employers to back up all their online safety records, because too often we see situations where companies have kept safety records diligently, but they are lost in a company move or a software change or through flood or fire. We recommend that all safety documents be kept for a period of 7 years. As a reminder of how to avoid risks, employers would be well advised to put up signs in the workplace reminding staff about safe manual handling practices. And I'm not talking about putting a note on a generic notice board. I'm talking about signs placed strategically around the worksite where the hazards occur and placed in such a position that they can't be ignored. Again, the placement and purchase of these signs should be documented so that you can rely on them if necessary. For those workers who go out on the road, like truck drivers or delivery drivers, safe lifting themed stickers can be placed on the vehicles. As we've said before, just as important as the training is evidence of its enforcement, so often we see cases where an employer's manual handling training has been comprehensive, but there's no evidence that it's being enforced. To address that, one thing employers could do is to give each supervisor a diary in which the supervisors record all the verbal directions given to staff about safety issues. For instance, if a supervisor one day sees a worker lifting with his back instead of his legs, he could simply record in the diary that on this date and at this time, he saw Joe Bloggs doing this, and he was told to plan the lift with his legs and keep the load close to the torso. If a handwritten diary is not feasible or likely to be lost, another thing employers can do is to create a WhatsApp chat group of the managers and supervisors in which they record what directions have been given to staff about manual handling and other safety issues. Now, with both the diary and the WhatsApp group, employers then have a contemporaneous record of manual handling and other safety issues being enforced. Now, I'm quite sure that right now there would be some employers listening to what we're saying and thinking that assessing and managing risk is an extremely difficult and costly task. Employers don't have infinite money and time to spend on safety. We get that. To address those concerns, what Liz and I would say is this. Firstly, regarding risk assessments, it's not necessary to assess every single task, but it is necessary to identify and assess the foreseeable hazardous risks. Risk assessment can be a difficult and costly undertaking. If employers are uncertain about what the risks are in their business, they can engage an ergonomist or a physiotherapist or a work health and safety advisor to advise on the risks. There is an entire industry out there to help employers with risk assessment, and they provide services at various price points. Training can also be a significant expense and a very time-consuming activity to ensure that it's comprehensive and directed to these specific risks. Again, a work health and safety advisor can direct employers as to the best way to train and retrain. Now, once employers have identified these specific risks and put the training in place to address those risks, it's then just a case of managing the risks with supervision and reminders, namely with the toolbox talks, the supervisor diaries, the WhatsApp groups, etc. All those latter steps involve minimal expense.
As mentioned by Duncan, evidence is going to be key for the defence of manual handling claims. As I was rereading the Whitley case, which was the dog food and the paddle grip technique, it reiterated to me the benefit of having managers or supervisors in your organisation who have practical experience in all aspects of the roles that report up to them. Now, this allows for an even greater level of assessment of risk, as a supervisor can speak to their own experience. There is a further benefit, as you can see from Whitley, that should a trial ever occur, you would have a senior person in your organisation that can provide evidence and specifically speak to their own experience and knowledge of the risk. The benefit of this is not just at a trial, but also that that person could provide a statement in the course of a common law claim to support the employer's position. This flows into my next tip. And from working with many of the employers that I deal with, I know many organisations already take this step, but do not underestimate the advantage of having a regular scheduled walk through your premises to look for new or emerging hazards. While day in, day out, it may seem that you are dealing with the same risks, it will be helpful in defending a manual handling claim to be able to show that you were routinely looking out for those risks and looking at how you would proactively respond to them. It's also very important to document this, be it in a diary or a WhatsApp group, as suggested by Duncan. In the course of doing a walkthrough of your sites, you could also seek feedback from your staff on the ground as to any emerging hazards. This, once again, has a dual benefit of allowing you to be aware of what's happening, but also allows you to check in with your staff regularly, which might also have another benefit of helping to minimise any psychosocial issues, but may also help to avoid any injuries that could be caused over a period of time rather than as a discrete event. If you're hearing about these matters on the ground on the day, you can respond to them and nip any risk in the bud, so to speak. Now, what we have on the slide here is just a very brief short list of some resources that you might like to turn your mind to.
Thank you. We'll send the slides out, and they will have the links live in there, so you should be able to access everything, including hopefully the cases will link to cases if you enjoy reading case law. We'll start with the five questions that came through on registration. Sorry, just to reiterate, we're not providing work health and safety advice. These are more observations, I suppose, from lawyers who've dealt with damages claims on these issues. Observations from experience in dealing with them, and so far it's been very helpful. I'll just start up there with the first one. So for manual handling training, what is considered best practice for delivery, method and frequency? I suppose you've already sort of touched on this, but if we could just, I suppose,
clarify. And I'm probably going to sound like a broken record. From the cases you've seen today, it's probably going to be no surprise that I reiterate that the training needs to be specific to the actual work being completed by the worker and targeted to the risks that might eventuate. You need to be discussing with your staff specific manual handling techniques and what those are and what's appropriate for those tasks. Very brief or tick and flick training is not going to be sufficient to meet your duty of care. Now, the training can be online or in person. That will depend on the task being completed by your workers, and you need to consider whether it's necessary to have a physical demonstration of the tasks that are being carried out to meet your duty. In terms of mode or frequency of the training, we don't have a lot of suggestion from the courts as to what this is, but certainly if you're having your training conducted on a yearly or 6 monthly basis with ongoing refresher training that is documented, that will be helpful for defence of a claim.
Excellent. The second question there, how can we best manage manual handling when our workers are lone workers? That's similar to one that's come in on the fly as well, which talks about, I suppose specifically the question here was about signage reminders. If you could all just roll this into the one answer, sorry. But this talks about where there's no work site and also where people work from home.
Yeah, this is a very good question. A common and difficult problem for employers of truck drivers, delivery drivers, and people who work from home is that they are outside the workplace and they effectively cannot be supervised. What I advise employers in this situation is this. Firstly, make the manual handling training as comprehensive as possible, document it, refresh it at least once a year. The higher the risk and the more serious the injury, the more you would want to retrain. Give workers reminders about safe manual handling. Exactly how this is done depends on the work and the worker. But one thing I have seen, which is effective, is that when lone workers log on to work, they have to first read a safety bulletin before they can start their shift. If workers are operating trucks or mobile plant, you can put stickers on the vehicles reminding them about safe lifting practices. And finally, employers can conduct audits of safe work practices on particular workers. For example, with a truck driver, a manager could go out on the road with the driver for a day or a part of a day to ensure that the worker is following safe work procedures. The manager would have a checklist and assess each work practice and tick them off as they go. That can be very compelling evidence if the checklist is a meaningful one and not just a tick and flick exercise. Depending on how risky the tasks are, employers would be best advised to do these at least twice a year.
Number 3, This is asking, I suppose, and from your experience, is there an increased common law risk if training is online only versus face-to-face?
I may have alluded to my thoughts about this in an earlier question, but I don't necessarily think that face-to-face training is superior to online training. But once again, it will depend on the nature of the training and the specific task itself. For instance, if a task requires hands-on training, such as using a specific piece of equipment or to teach a specific style of manual handling, I suspect an employer will be penalised for failing to take that step. Otherwise, I would point you back to the Solomona case where that plaintiff received 8 hours of online training, among other things, and the court considered that she was appropriately trained and the claim failed. So I wouldn't say there's a difference in liability risk. I think the same liability risks arise for the employers with both modes of training, but it's for the employer to appropriately consider and manage those risks and have a really good think about, can I properly train my employee online or does it need to be face-to-face?
Terrific. Question 4 is about repetitive strain injuries in manual handling. So any sort of tips or recommendations or things you've seen, I suppose, when handling the defensive claims for those types of injuries, the examples there being working for a long period of time, making beds and carrying items.
Yes, it's very important to warn workers about the risks of repetitive strain and to encourage them to report any symptoms as soon as possible. Liz and I aren't doctors, but it's fair to say that the earlier the symptoms are addressed, the more likely there'll be a better medical outcome. Effective supervision is also very important, especially when workers are under time pressures. Supervisors and managers need to understand that workers under time pressure will often find shortcuts. Supervisors and managers need to stop these shortcuts from happening before they take hold. They need to observe and record any directions given to staff about safe work practices. If we take the example of a hotel employee making beds, for instance, employers would want to take periodic audits of the workers to ensure that they are doing the job according to their training and, of course, document those audits. Finally, job rotation is extremely important to avoiding repetitive strain injuries. To the extent possible, the repetitive tasks should be shared and rotated amongst staff. And again, documentation of that job rotation is very important if you want to rely on that as a defence to the claim.
Thank you. The last of the pre-prepared questions is about adjustment disorders, which of course are very common secondary injuries for musculoskeletal claims. Obviously avoid going into medical advice again, but any advice or any observations from what you've seen about what employers can do proactively to demonstrate due diligence?
There's a lot to unpack in this question. And firstly, I'm going to point to the fact that I know WorkCover Queensland has a very large number of resources available on its website dealing with psychological injuries specifically, and I would direct you to those in the first instance. Quite clearly by the name, an adjustment disorder is the worker's response to the injury suffered. For me, the best organisational response is aimed at helping the worker get back to the role or as close to their role as possible. Speaking from my own experience of what I'm seeing organisations do very well in the secondary psychological injury space, and probably generally on a statutory claim level and perhaps also, but less so in the common law claim, what they're doing is they're having a really quick response time following any notification of concerns, be that a quick phone call or an email to acknowledge the worker right at the get-go. What I'm seeing is timely investigation if there's something that needs to be investigated, and transparency around the process and any timeframes that might be at play. I see the employers continuing to touch base with the worker, again by phone if it's appropriate, or by email or text. I'm seeing early engagement with psychological providers, and WorkCover Queensland does routinely fund psychological support services in the course of claims. And lastly, I would say there's early discussions being had from the get-go and in conjunction with the medical advice about possible return to work options or job modifications once rehabilitation is complete to get the worker back into the job as soon as possible.
Thank you. You touched on something I was going to add. I think I add it to every webinar, which is that piece of if an injury does happen, despite your best efforts, obviously, the best thing you can do is support your worker and ensure they're okay and help them rehabilitate back to work. Achieves the best outcome for everyone in everyone's experience. Those were the questions that we had on notice. And so now we go to the ones where we put you on the spot that have come through, which Elise has passed to me. The first one was one I jotted down to ask you, and then I think you sort of answered it towards the end, Duncan, but you were talking about supervision and evidence of ongoing supervision and enforcement of these processes in place. And the question is around how do you demonstrate that, on what level of supervision is considered adequate. I think you touched on that sort of with the diary and the WhatsApp group, but is that the sort of thing you would look for from an employer when you ask for evidence of ongoing supervision in the workplace?
Well, the level of supervision that's required depends on the level of risk associated with the tasks and the frequency with which they occur. If it's a risky task done daily, you would want to see evidence of regular supervision, be it through the supervisor diaries, the WhatsApp groups, the audits of particular workers, the weekly or perhaps daily walkthroughs. For the less serious tasks, those check-ins by supervisors can be more sporadic.
Thank you. The next one we've had come through is about, it's a tricky topic, but degenerative conditions, or I suppose also pre-existing conditions that might pose a risk to someone who's doing manual handling tasks. I suppose a higher risk to someone without such a pre-existing issue. How could that be accounted for, and how to deal with it if it's not disclosed by the employee? Not straightforward.
I think the first thing I'd say is what I see a lot of the time, and I think a lot of employers do have these days, is that early medical form. When you start your job, you're filling in to say, do you have any issues with your back? Do you have any issues with your shoulder? And they're asking them to specifically say, do you have any issues that you're aware of? Because that's what we're really interested in, right? Are you aware of symptoms or problems that you are aware of that will impact you? The second thing I would say is that employers are not expected to be medical practitioners. They're not expected to be experts. All you can do is what you can based on the material before you. So if you have a staff member that says, I'm perfectly fine, I'm able to do my job, and you're not seeing anything in them on a day-to-day basis that causes you concern, you're entitled to presume that they are able to do that work. And I think I'm quoting on the spot, but I want to say Barbara and Somerset Council is the case citation for that. You are entitled to presume your employee is able to withstand the ordinary hazards of their role. I'm not sure if Duncan has any other thoughts to add to that.
Nothing to add.
Well, if that's a case relevant to the question, we might put that into the slides as well if people want to have a read of that when we send them out. Of the ones I have in front of me, the third one we rolled into one of the other questions, and the fourth one is really just a question about, I suppose, signage on its own, which I feel like we've probably already covered. Is signage on its own an acceptable control? Would you like to expand on?
No, it should be one of several aspects of training and risk assessment. I think it should be appreciated that signs, if they're seen on a daily basis, will, after a while, become less visible. So that's precisely why that you can't rely on signs alone. It needs to be backed up with regular reminders, toolbox talks, walkthroughs, etc.
Agreed. You can't just have signage on its own. Exactly what Duncan said. It's got to be part of a comprehensive consideration of the risks that you have.
Excellent, thank you. I think I saw some more questions come through, but I'm sorry, I don't have those in front of me. I did see a question just pop up on the screen saying this is being recorded. It has been recorded. It will go up on the YouTube channel, and we'll also send out the links. We will wrap it up there since we're out of questions for now. If there's something you've asked and we weren't able to get to it, I'm sorry about that, but as I said at the start, please feel free to reach out to a customer advisor or relationship manager you've got here. Thank you very much, Elizabeth and Duncan, for presenting, and Elise for organising all this for us. I also said you can go to our YouTube channel. You can check out all the past ones there. I was also going to remind people, I think 2023, about this time of year, we did one on Christmas parties. So if that's relevant to you, go and check out that one about staying safe at Christmas functions and liability relating to Christmas functions, topical. We send out the survey I mentioned. We do appreciate your feedback. So if you enjoy these and if you think they're valuable, please let us know. I think if there's space in there to type, which I think there is, please also feel free to suggest future topics because we're open to ideas in the new year. Otherwise, that's all from us. Oh yeah, we'll send out links. The next time we do one, we'll send out an email with links and we'll advertise the ones we do in the new year. But thanks again to our guest presenters. That's all from us today. Please, everyone, stay safe over the festive season, and hopefully we'll see you next year.